Hey everybody, I'm Kim Wehle. Welcome to the Little Law School. The topic for today is whether the U.S. Supreme Court is political. We hear this a lot, and frankly, I'm one of the people out there that in the last few years have become critical of the U.S. Supreme Court. And so the answer is possibly, but it leads to a broader foundational question, and that is, are courts political? And what is the difference between courts and politicians? There is a really important legal distinction between what politicians do and what judges do, and that does get lost in our national debate. Setting aside the Supreme Court for now, judges, juries on one hand, politicians, presidential candidates, members of Congress on the other. Very, very different. Let me start by explaining what the U.S. Supreme Court in the early 20th century has said in terms of defining the difference between politics and judicial decisions. Politics or politicians produce oftentimes legislation. They're members of Congress or they're state legislators or they are municipal council people that pass laws. When a law is passed, the legislators use very generic information. Take an example of stink eye in the metro. They might gather people to hold hearings and talk about how bad stink eye in the metro is to people, and we need a law managing that. It's very generic facts. So they'll pass a law. The law applies to everyone in the future. It's very general and it's very future-oriented. You can't, with rare exceptions, apply a law to something that happened in the past. They're making new rules prospectively. The difference between that and a judicial decision is when someone files a lawsuit, they're complaining about something that happened in the past. The plaintiff is mad at the defendant for something. As I tell my students, you can always boil a case facts down to once upon a time, someone got really mad at someone. And when a judge weighs in, they're weighing in on something retroactive that happened in the past, and it only applies to the particular parties before the court. They can issue a ruling that favors one party over the other. So that's one big difference. Judges are backward thinking and very narrow in the scope of what they do. Legislators, politicians are forward thinking and they apply to everybody. Their rules, their laws apply to everybody. That's number one. The second thing is the garbage in, garbage out principle. When it comes to politics, particularly in the digital age, there's a lot of garbage. There's actually false information that's planted on the internet by people that want to sell things, by our foreign adversaries, people that don't want America to thrive. They produce falsehoods, they circulate them on the internet, and studies show that lies circulate much faster than truth. And frankly, the framers of the Constitution understood that as well. So we as consumers, when it comes to voting, when it comes to supporting politicians' policy agendas or listening to their rhetoric and their speeches, it's overwhelming to actually figure out what's true and what's not. It really requires us to do our own research, to identify good media outlets that police themselves for accuracy, and maybe even click on hyperlinks to read original sources ourselves, read the law, or read the press release out of the Department of Justice, or read the indictment, or read someone's testimony. Sometimes that is actually reproduced online, so you can look and read it yourself, but it takes a lot of time. So it's sort of the Wild West when it comes to facts with politicians. With courts and lawyers and judges, there are a lot of wickets that have to be gone through in order to get information before a jury or a judge if the judge is making a decision regarding the facts. So back to my once upon a time, plaintiff got mad at defendant. Plaintiff's going to have one version of events, defendant's going to have another version of events. There are complex procedural rules that the judge must follow to get the facts exchanged, to get information before a jury, and there are rules of evidence that are designed to make sure the jury doesn't have garbage, that whatever they hear is verifiable, reliable, accurate, that if they hear an expert opinion, that person actually is an expert. That's a big difference between politics and law. Law has those kind of gatekeepers to make sure information is accurate. In addition, there are constitutional guarantees for criminal defendants. There's Fourth Amendment, Fifth Amendment, Sixth Amendment, a bunch of things that are put into place to make sure or to maximize the possibility of fairness in that process. And another really big thing is there are appeals. In judicial decisions, in the court system, there are appellate courts and then Supreme Courts at the state level, and then even the U.S. Supreme Court all the way to the top. So there are other judges grading lower court judges' papers, so to speak. The downside is it takes a lot of time. It takes months, sometimes years. And in this moment, when we're seeing with the Trump trials, the legal system dealing with the failures of politics, to hold politicians and the lies and the transgressions and the legal violations accountable, it's getting pushed to the courts and it's taking a long time. And that's understandably frustrating. But one of the reasons it takes a long time is because there are all these standards to make sure that things are accurate and that it's fair, in this case, to Donald Trump, the defendant. Now, I've talked more about those trials and I'll continue to talk about those trials. But for now, keep in mind that the court system in this moment, with some rare exceptions, is actually functioning and working. And even with the rare exceptions, some kind of renegade judges out of Texas, for example, that are really kind of making decisions that are outside the norm for courts, those things go on appeal and can be reversed by a higher court. Okay. So that's the good news. The courts are really still working in America. They take a long time. The facts with respect to politicians is a bunch of garbage to a large degree, and it's on us to make sure we have good information. I want to circle back lastly then to this idea: is the Supreme Court ideological? Is the Supreme Court political? The U.S. Supreme Court is the one exception to what I just explained. There is no appeal from the U.S. Supreme Court. There is no higher court to grade its papers. The highest law is the Constitution, and that's very hard to amend. It takes super majorities in both houses of Congress and in a majority of state legislators to actually get out a pen and paper or a computer and add or subtract stuff from the actual text of the Constitution. Back in the early 1800s, in a famous case called Marbury versus Madison, the U.S. Supreme Court gave itself the power to interpret the Constitution definitively. The Constitution itself doesn't say the Supreme Court decides what the Constitution means. It doesn't say Congress decides what the Constitution means. It doesn't say the president decides what the Constitution means. That's vague. It's not in the actual text. But since 1804, Marbury versus Madison, we the people and politicians, other judges, and presidents, we've all accepted Marbury versus Madison and this idea that the Supreme Court gets the final say on the Constitution. And when it does that, when it interprets ambiguous language, that actually functions like an amendment to the Constitution. When it takes a word like two words like due process and says, what does that mean? That's kind of giving a definition to the Constitution. That's the highest law of the land because the Supreme Court gets the last say. When it interprets what's an unreasonable search or seizure under the Fourth Amendment, or what does a well-regulated militia and the right to bear arms mean under the Second Amendment, or what is free speech or freedom of expression under the First Amendment. Those things are not defined. So anybody who says there are certain good and bad judges based on whether they're interpreting language is lying. They're duping people because a lot of the Constitution is vague and you have to interpret it. So conservative judges interpret it and liberal judges interpret it. The question is, what tools do they use to resolve the ambiguity? No one is just applying the plain language. That's just not happening. And so to suggest it is, you have to ask, okay, what are you hiding? And that's my concern right now with some of the justices on the Supreme Court. There's this pretense that they're being conservative, but they're actually being extremely radical. So in some cases. So is the Supreme Court political and ideological? Yes, unfortunately. That's probably been the case for many years, but I think right now, for a number of reasons, it's extremely so. But that's just because there is no higher power to the Supreme Court in the United States. And the framers of the Constitution understood that it's human nature in our brains. If we get power, we want to amass it We want to entrench it, and ultimately we'll abuse it unless there's some internal benchmarks or some outer mechanisms of accountability. And that's really a problem with the Supreme Court. So I hope that's some clarification for folks. Law versus policy, are judges and juries to be not trusted? The answer is, for the most part, we can trust them. Thanks for coming to the Little Law School today.